This Honorable Court of Appeals is now in session. Please be seated.
Good afternoon. Welcome to the afternoon session of the Court of Appeals. Your panel today includes Judge McGee from Savannah, Judge Armstrong from Shelby County, and I'm Judge Golden from Memphis. Do we have any announcements?
No, Your Honor.
You may call the first case.
Ricky L. Boren et al. Versus Hill Boren PC et al.
Good morning, Your Honor. Or afternoon. Look, you can tell I'm nervous. I'm Tamara Hill, and I represent the defendants, appellants in this case, T. Robert Hill and Hill Boren PC, and I would like to reserve 3 minutes for rebuttal, please.
All right, 3 minutes. You may proceed.
Thank you, Your Honor. May it please the court. Defendant Hill and intervener Ms. Hill rely on the brief and reply brief submitted to this court and would add as follows. These issues are before the court as a result of attempts to execute on statutorily protected and jointly owned property. They're much bigger than one man and one family. Any Tennessean with an IRA will be affected. 262105 exists to encourage saving for retirement. There will be no reason to contribute to an IRA if 262105 protections mean nothing. And if the trial court is upheld, 262105 really does become meaningless. All anyone has to do is to continually renew a judgment every 10 years until a defendant reaches retirement age and then collect. People might as well enjoy the money and let the government take care of them when they retire. TCH.
Pardon me, why do
sorry.
you say that reaching a certain age makes a difference in terms of whether the annuity or IRA is exempt from creditors?
Well, Your Honor, under my understanding of the trial court's decision is that because Mr. Hill had reached over the age of 59 and a half, that Tennessee 262111D2 made his retirement account completely accessible and completely subject to depletion by his creditors simply because he was old enough to begin to take it. Now, we will show that that's actually not the case. He actually cannot take it out as he would like to take it. The Sun America plan, the Prudential plan, and the...
Let me ask you, what language in the trial court's order suggests that what you just argued, that because you reach a certain age and you can start and you can draw without penalty or whatever, that is no longer protected? Because as I read the order, it seems to suggest that if you have a right to elect to receive a lump sum, that's a disqualifying provision in your protected IRA or annuity.
Correct, Your Honor. And what I believe the trial court assumed is that Mr. Hill had the right to make that election because he was of retirement age and could now withdraw it without an IRS penalty. However, the annuities themselves provide that once the payments have begun, and those began for Mr. Hill because he was 70 and a half in 2014, those began in 2015, and those are locked in, so he can only take periodic payments of the same amount unless the RMD increases over the life of the annuity plan. So Mr. Hill cannot, in effect, actually elect to take the whole thing in a lump sum or to take it in less than 60 months. And the only explanation I have for the trial court saying that he could do that was that he had reached the age to be able to withdraw it. And that's what plaintiffs argued. He'd reached the age to withdraw it. In fact, they even argued that, well, if he were in his 50s, we couldn't do this because he couldn't take it. But because he's over that age, we can. So that would be, I mean, that's the best way I know to answer that question, Your Honor.
Okay.
I would say that Tennessee 262105B's prohibition on subpoenas of the 408 retirement plan records would prevail over any perceived entitlement granted by common law or rule of court. I know there was an argument that, well, we could have gotten that in discovery anyway, but Gardner, a 2021 opinion by this court, says that the statute actually trumps the common law, so they cannot get these under subpoena because the statute clearly says exempt from subpoena. And Moore, a 1970 Tennessee Supreme Court case, also says that Rule 6903 does not trump the statute that says you can't have this stuff. It's supposed to be protected for retirees. That was the whole purpose, and I think I shared with the court in our brief the links to the discussions that our legislature had about the fact that they wanted to protect retirees. They wanted to encourage people to save for retirement so that they did not end up being taken care of by the state or federal government. What taking this 408 retirement plan and allowing them to take it all essentially puts Mr. Hale back as dependent on the government, which destroys the whole purpose of 262105. If it's exempt under 262105, but 262111 takes it away the minute you can get it, then it's useless. Plans were
Well,
never.
that's
I'm
not
sorry.
what 262111 or the opinion in Massey necessarily says, though.
Well,
That simply because you can take it means it loses its exemption. That's not what the case says. That's not what the statute says. You know, the statute says that if you can draw it over a period less than 5 years, or if you can elect to take a lump sum, then the protection is not provided, is what the statute says.
which means for anyone that has reached the age of 59 and a half and can take their retirement plan, unless, if Mr. Hill didn't have the annuities that said he couldn't take them, a retiree can take their money when they reach the age of retirement. They have to pay taxes on it, but there's no IRS penalty. So in essence, what interpreting it that way does is say, okay, it's protected because you can't take it until you get 59 and a half, but the minute you turn 59 and a half, then you can take it all. So this 105 means nothing. It's just poof, it's gone once you reach the age of retirement. I understand what you're saying, that if you can elect to take it over less than 60 months, or you can elect to take it in a lump sum, then that's the only thing that removes it. But that's exactly what they argued, that because Mr. Hill is 78 years old and has no time to rebuild a retirement, that now his retirement is fair game, simply because he's reached the age. And 262111 1D1 says that age is one of the exemptions, that if you reach it because of age, it's still exempt. And then A, B, and C has, if it's an insider, and it's age, and it's not 408 or those other listed plans, then it's not exempt. The problem with Massey, and I don't mean to be disrespectful, but Massey quotes 26 to 111-1D3. That doesn't exist. 26-111-D1 has the first section that talks about the exemptions. Then it has A, B, and C that tells you you've got to meet all these three things. And if all of those three things are met, then it's taken away. Then it moves to D2. D1 is about the payments. D2 is about the assets from which the payments are made. Logic dictates that if the payments themselves are exempt under D1, then how can the funds from which the exempt payments are made, are not exempt because you take that all away, and then there's nothing to make the payments that were exempt to begin with from. I think what 111 actually represents is deferred compensation plans, things like that that are not covered under 105. And you look at D1, and if those plans are as a result of an insider, on account of age, and they're a deferred compensation plan or one of those others that do not meet C, then a creditor can start taking those payments. But then only then do you look at D2 to see if the creditor can go ahead and get everything they're owed from the assets, or if they have to take those payments as they come due until the debt is paid. Also want to spend just a moment on the RV. And I would say that we provided a chart of the similarities between the Hills and the McAmis and the Katz, as well as the differences between the Hills, the Lamberts, the Belches, the Citizens case, and the Hunts. Even Mr. Boren testified under oath at the trial that the RV was their RV, that they took their RV to Minnesota. So I feel like he would be stopped at this point to say it's not their RV. Everything that the Oliphant case used to find that the property was joint, the trial court used to find that the property wasn't joint. Mrs. McAmis put Mr. McAmis on her property to protect him, so she knew what she was doing. But the trial court found that while the property wasn't in dispute, it did show their due regard for one another during their lifetime and after death. Mr. Hill missed one thing, the RV. He put everything else in joint names and as an oversight, missed the RV. But he held it out to everyone that it was our RV. The bank financial statements that they required show that the RV was owned jointly. Mr. Boren testified, their RV. The RV belongs to both of us. Just because Mr. Hill failed to fix that after his divorce does not mean that it's not both of ours. And I have 30 seconds, so any other questions?
You'll have your rebuttal time.
I'm sorry?
You'll have your rebuttal time.
Thank you.
Members of the panel, may it please the court, my name is Teresa Luna, and I represent Ricky Boren and Jeff Boyd. Mr. Hill has appealed 4 issues concerning the execution matters. A close look at his list of the issues is very important because he's not only argued the 4 listed ones in his brief, he's made several other extraneous arguments that do not fit under any of the categories of his issues. His listed issues are whether the trial court properly allowed a subpoena of his IRA records, whether his IRA was exempt from creditors due to his age, whether the trial court had subject matter jurisdiction over his RV, and whether the trial court erred in refusing to hear Mrs. Hill's motion for summary judgment about the RV. We would therefore urge the court to make its ruling based on these 4 listed issues and not consider the several other extraneous arguments that Hill has interspersed in his brief. Under Watkins v. Watkins, 2017 Tennessee Court of Appeals case, an extraneous argument may be deemed waived when it's argued in the brief but not designated as an issue as required under Rule 27 of the Rules of Appellate Procedure. His first listed issue concerns the subpoena of his IRA. He argues that 26-2105B prevents such a subpoena. However, when the court looked at this issue, it found that possibly Hill's IRA was not exempt under a sister statute, 26-111. So therefore, it felt that it needed to look at those documents to make the determination. Also, I would like to point out that Hill heavily relies on these documents himself in all parts of his brief. But maybe the most compelling reason is because Hill was supposed to turn these documents over in discovery. They were requested in post-judgment discovery. Hill refused to turn them over, and the court ordered that Boren and Boyd could subpoena them because of Hill's refusal. Hill's second listed issue is whether his IRAs are exempt due to his age. Again, the statute, as Ms. Hill has mentioned, the statutes involved are 26-2105 and 26-2111. 26-2111 has a clear exception to the exemption that's found in 105. The court was previously found, had to deal with this in Massey versus Casal back in 2011. But first, I would like to address some issues that Mr. Hill brought up in his reply brief, if I may. First, concerning that penalty of law provision, which becomes very important. It's in 111, it's in section 111. It provides that if a person can withdraw funds in a lump sum without penalty of law, then the IRA is not exempt. The penalty of law that it's talking about comes from the IRS code. 26 U.S.C. 408B is where you find the provision regarding individual IRAs and regarding the annuities that are found within those IRAs. That statute also references 26 U.S.C. 72Q. That statute says if a person is over 59 and a half years old, there is no penalty of law when withdrawing the funds from an IRA. So that's the penalty of law that was referenced in section 111. It's not referring to any kind of internal penalties or charges or fees that the investment company may charge the owner of the annuitant. That's not a penalty of law, and that's what Mrs. Hill was referencing. And Hill clearly states in his brief that he's 78 years old, so he can withdraw this money in a lump sum without penalty of law. Now about the lump
Is that
sum.
provided for by his annuity or IRA contract, that
It
he
is.
can withdraw the entire amount?
It is. And Your Honor, I'll tell you where that's found. In Volume 19, Parts 1 through 5, those are the documents that the trial court relied upon for its August 2021 ruling. And you'll see in there not only the statements, but you'll see the contract documents as well. And those documents clearly state, I would point you first to the Morgan Stanley statements. Those are in Part 1. The statements are there from 2013 to 2021. Every one of those statements say that there is a cash surrender amount, that Hill may take that cash surrender amount. And then when you go to the contract
I'm
documents.
sorry. You say at each one they say there's a cash surrender amount. Does it actually go on to say and that you can take that at any time? Because just because you have the cash surrender doesn't mean that you can take it at any time. A lot of times that's stated because that's what you can withdraw, or somebody can withdraw upon death of that party,
Right.
not necessarily the party.
And I'd refer the court to the contract documents there. And those contract documents for those annuities are found in Parts 2 through 5 of Volume 19. Again, that's what the trial court reviewed. And what you'll see is that, and I want to again reference what you were asking Mrs. Hill about the withdrawals. And she said you can't withdraw it after you reach a certain age. That's not what those contract documents say. What they say is you can withdraw it, but it's going to affect your payment that your retirement payment that you get each month. Now, of course, if you withdraw a lump sum, you certainly can't expect to keep getting those same withdrawal payments each year. But that's not what we're talking about here. It's the ability to withdraw it in a lump sum amount. And as Judge Davies found, Volume 19, Parts 1 through 5, have the documents that show that.
So let me make sure I'm clear about your position. Is your position that any qualified annuity, any qualified RA that is protected becomes unprotected when the party reaches a specific age?
I think it depends on two things, Your Honor. I think it depends on the 59.5 provision found in 26 U.S.C. 72Q, and I think it also comes down to the contract documents themselves, and that's where we've referenced them in Volume 19. that those documents, there's nothing in there that says that he can't withdraw them in a lump sum. It's just going to impact his yearly withdrawal payments if he does. And there may be a certain fee that is imposed by the investment company if he does, but that's not a penalty of law.
Okay.
Therefore, Mr. Hill's been able to withdraw these withdraw this fund, the money in this fund for the last 20 years without a penalty of law, and he can withdraw them in a lump sum. When Judge Farmer wrote the Massey opinion, he opined on several things. The first was that there were two competing goals in here. One is we want to encourage citizens to save for their retirement, but we also want to make sure that we're limiting the means for these debtors to shelter large sums of money from their legitimate creditors. Basically, what Massey's holding is if a judgment debtor can access his funds without a penalty of law, then so can the judgment creditor. Hill makes an argument about the legislative history, and I just want to really quickly point out that if you'll look at the legislative history or the archived history of the statute itself, 105, you'll see that it's been amended 6 different times since its inception in 1978. If the legislature had not wanted the Massey ruling to stand, it could have and would have changed Section 105 or changed Section 111 and has never done so. About the RV, that's Hill's third listed issue, whether the trial court had jurisdiction over that. That's a really simple answer. In June of 2020, the trial court found that it did have jurisdiction. That issue had made it up to this court and had come back down again, and the judge ruled that it did have jurisdiction and that the only thing that the declaratory judgment action, which is a separately filed action by Mrs. Hill, the only thing that it covered was the bank accounts that were at issue. So I would urge you to look at the Ammons v. Longworth case, Tennessee Court of Appeals of 2019. That held that a trial court still has jurisdiction over collection and enforcement of the judgment matters, even when the case is up on appeal. Now, Mr. Hill has inserted numerous extraneous arguments in his brief that are not listed as issues. The first one has to do with 567203 and whether Mrs. Hill is a beneficiary under the annuity. It's not listed as an issue, but he does make an argument about it. The next one is that he argues that he owns the RV jointly with Mrs. Hill. That's not listed as an issue. He argues that the prior suit pending doctrine applies, that Tamara Hill was forced to intervene, and that the trial court would not waive his bond on appeal. I would like to address first one that Mrs. Hill didn't address, and again, we would urge the court not to take it up. But in 567203, you'll notice that the court entered an order back in 2021 in January, and it found that 567203 did apply. Then it reversed itself and came back in July of 2021 and found that 567203 does not apply. Now, the court's reasoning was one thing, but the reasoning that we would ask the court to consider if it takes up the issue is that these annuities, clearly from the contract documents you'll see, they are not for the benefit of Tamara Hill. Mr. Hill has checked the boxes over and over again in those contract documents to say this is for retirement income, and therefore 567203 does not apply. The fourth issue that was listed by the Hills was whether Mrs. Hill's summary judgment motion was wrongly denied concerning the RV. I'd ask the court to look at the history of this. First, Mrs. Hill and Mr. Hill brought up the issue late in 2019. The court held a hearing in January of 2020. It heard Mr. Hill's testimony, took documentary evidence, and then the issue kind of got on the back burner because the certain jurisdiction issue came to this court. But when it got back on the front burner again, the court said in the summer of 2021 at a hearing, I'm about to rule on the RV. Mrs. Hill then filed a motion for summary judgment and presented a couple of affidavits from her and from Mr. Hill with some additional facts. Now, the court issued an order denying it, but this is what he said in the order and in his letter he submitted with it. I've already started hearing this matter. There's already been testamentary evidence. There's already been documentary evidence entered on the record. And so I'm not going to prevent you from presenting this evidence, but we're going to do it at a hearing. And so he held hearings in September and October of 2021, and the court made a ruling on that. Now, because this is a denial of summary judgment based on facts, and those facts were later heard by the court, the summary judgment is not reviewable by this court now. And if there's no other questions, I'll relinquish the end of my time.
Thank you. You have 3 minutes, Ms. Hill.
Thank you, Your Honor. I will just say 26-111 does not mention subpoena. 26-105 forbids subpoena. I think Ms. Luna answered your question, Your Honor. They do definitely intend that once you reach retirement, anybody can take your IRA. I think that made that position pretty clear. We have provided the language from the documents that say that Mr. Hill cannot take his retirement in a lump sum, and those specific pages are pointed out in our brief. I apologize, I don't have all those pages in front of me at this point, but we have directed you to specific pages that show that he cannot take those, because all of these things their annuity date came before the lawsuit was ever filed. Again, he's 78 and a half. Lawsuit was filed in 2016. He was already 72? I could be wrong. I urge the court to follow Kelly and actually look at the documents. And the for the benefit of argument, I think we addressed it in our brief and probably in our reply. The annuities themselves, the Morgan Stanley account itself, says they are for the benefit of the owner and the beneficiary. That's what the word beneficiary means.
Is that true for all three?
Yes, Your Honor. All three of them. The Morgan Stanley custodial account says that, and then all of the annuities say that as well. You can pick a living benefit, but that doesn't destroy the death benefit. It's not like if you select a living benefit and you're getting these payments for your retirement and you die, that the death benefit goes, he could drop dead tomorrow. And I don't think he's going to. He's in pretty good shape. But whatever's left in there goes to me. So yes, it's for my benefit also. So 567203 does indeed apply and was used as recently as 2007 in Ray Billings, I believe it was.
What about the argument that the only issue you raised about the RV was whether or not the court had jurisdiction?
I believe that my statement of issues was very inartful, and I apologize for that, but I do believe that it covers the ownership issue as well as the jurisdiction.
But obviously you don't say that in your statement of issues, do you?
I would have to look at my statement of issues again. I know that I reviewed it when they raised that, and I believe that when I read it, I believe that it said ownership and jurisdiction.
And your lawsuit wouldn't be a prior suit pending, would it?
Well, I believe that it would, because there was no final judgment until well after March 23rd of 2021, because this court decided that there was no final judgment in the underlying case. My DEC action was filed September of 2019, and my DEC action included not only the bank accounts, the RV, the Polaris Ranger, the Tahoe, the Mini Cooper, all of these things that we own together to get them declared as, yes, they're mine, or either they're jointly owned, so that we could remove that from consideration and move on to what was really pertinent.
But that lawsuit was filed after this lawsuit.
It was filed after this lawsuit, but not before there was a final judgment wherein,
Well, is that what you look to, whether or not there's a final judgment or the date of filing of the lawsuit to determine whether or not it's a prior suit pending?
I don't know, because the RV wasn't an issue in the underlying lawsuit. The underlying lawsuit was about a stock transfer agreement where they told this court, a month ago that the stock was worth $35,000, that he got a $35,000 credit for the stock. And what they didn't tell you is that for that $35,000 credit, they got control over $4 million. So they already got that. Yes, they've already got the $4 million control over that in exchange for $35,000 credit on stock. The law is supposed to be a tool to promote justice, not a weapon of mass destruction.
Thank you. May call the next case.